All right,
Good.
well, welcome everyone. For those who don't know me, my name is Andrew Veal. I'm an instruction specialist with the Arizona Bar Foundation. We do the mock mediation tournaments for Arizona. We help teachers implement mock mediation. And today we have with us John Lagg. So I'll go ahead and pass it over to you, John.
Hey, Andrea, thank you. And thanks to everybody attending today and last week. We have there 5 sessions total, you'll see. And they'll all kind of piecing together, sort of an overview, some overlap, if you will. Two things to remember. One is that this is generally instructional, what mediation and negotiation is, how mediation is a guided negotiation, the big picture on the techniques and the process itself, and with the view towards making it appropriate for the high school and middle school level, and with the view towards tournaments. So this can be used for training, general overview for personal growth. These are life skills. It's not just the lawyer tracks, although I teach law schools and others and lawyers and people. This is an adaptable skill for everybody. Everybody negotiates, everybody mediates somewhere along the line too. So we try to make it, again, with your guidance and questions, and we fine tuning as always, your comments to make it age appropriate, if you will, and educational and developmental levels appropriate for the secondary education and for the middle school. That being said, today's topic of the day is the opening statements. Again, initially, you got another slide there, please, Andrea. Thank you. Yes, so now let's at the preview. So again, mediation, again, too, we went over this a little bit. Facilitate, I call it a guided negotiation, a facilitated negotiation led by the mediators to resolve disputes collaboratively. Again, led by mediators, the level of involvement by mediators, for one, it's different from mediator, differs from the person, the human being is actually the mediator. Some are more active, some are more passive. So that's an art form to get the right balance, if you will, of actively guiding, if you will, sort of pushing in the right direction, if you will, or when things are productive and the parties are collaboratively working towards resolution and solutions, to pull back and clarify. You can always get involved in clarifying. Mediate is one of the key roles of a mediator too, is to clarify. Here's what I heard. A said this, B said that, because people hear one thing, they say another thing, they understand differently. So it's always good to clarify. So A, B, and C, okay, you said this, you said that. What I'm hearing, there's different skills. So key roles, mediators, a neutral facilitator. Again, they call it facilitated mediation when you're basically helping the parties, guiding the parties to resolve the dispute on their own, or at least working towards a resolution. It's also important too, especially in tournaments, there's no points, there's no absolutes that you have to resolve the case. Everybody shakes hand and goes their separate ways, and okay. I liken it to, it's more of a direction than an actual physical destination. What the resolution is, always guide toward the right way. There's a resolution, positive energy, as opposed to negative, negative comments and accusatory comments and posturing like we're going to beat you in court. It has to be in the right direction. Everything has to be done for the productivity. And especially if you have a 1 hour time limit in our tournaments, it's not necessarily going to have enough time to really get all the issues resolved. But just if it's going in the right direction and it's productive. Mediators, neutral facilitators. They don't judge. When you have courts, and again, these are different distinctions from other arbitrations or courts. In our American jurisprudence system is basically a blood sport. I like the euphemism I use. It's accusatory. It's to win, not only to win, but to beat the other party. The rules are set up for that, and Supreme Court justice had said it's sort of archaic, and there's got to be a better way, and the better way is a mediation. Again, mediators, neutral facilitators, go into a little more about their roles in a second, but the advocates, legal representatives summarizing the key issues. Now, it's important, the distinction. Advocates, where many times the cases are written where it's in court, it's advocate's a lawyer. And so here's the lawyer, here's the client. You're in court. It may be filed, it might be threatened lawsuits, it may not be in court, it may be in court, they may be during a trial. You can mediate during a trial. While a jury is deliberating, you can mediate cases and resolve cases. It happens oftentimes. Sometimes with a little over the topic level here today, but under a dispute after a trial, before the jury deliberates and gives their verdict, parties say, you know what? If they come in over 10 million, we'll limit to 5 million. We'll take a certain area between 3 and 5. If the jury comes back at $1, I'm going to still get $1 million. What there you can have that high low type of negotiation and mediation, because what's different, no circumstances, new information during the trial. They evaluate. My case might not be as strong or not. Some of the jurors were, looking down or so. You can always mediate. After trial mediation is also available, or negotiation, which it is. One party gets a judgment and the other likes it or doesn't. You may or not collect. There might be appeals, and goes on and on and on. So advocates' role, that's in a tradition. However, some of these cases, especially in these educational level, advocates can be parents. They could be their friends. They could be the dean of students at the school, or could be union members where they have the union representative. It's advocating on behalf of the union employee. Any number, use the people where everybody does it. Parents, you have 2 children, Johnny and Mary, they're fighting over whatever they do, and who gets involved. They don't resolve it on their own. Parent usually gets involved. Okay, what's going on? You do this, split the candy bar in half, whatever the case may be. That's a role that's people don't realize they're mediating, but they are. So there's advocates in this. They can be by the facts itself. You'll see if they're parents or whatever their role is, but they're the one advocating on behalf of someone. The client, those are the ones that have the dispute. It's clear enough. They have the issues. They have the crisis, if you will. So the advocate works with their clients. The mediator works. I like to say mediators work for both parties. They work against neither party. And that's unique to mediation also, because advocates, you represent your client zealously within the bounds of the law, as the black letter law. You have your client's best interest involved. You can't give up the secrets or tell anything else. You can't communicate with the other party. You have blinders on. You only see your client's position. All you do for that. Mediator works for both. Tries to get the parties to resolve the dispute. Next slide, please. Thank you. I'm going to get to opening statements, how it comes involved just a little bit. Again, each one of these sessions, we're talking the broader picture on mediation, if you will. Now, specifically, a little more the opening statements. So we're going to have, for today's topic, again, really the parts of mediation. The process will describe opening statements, caucus, and conference. So I'll explain a little here. Is that the mediation process? First of all, you're in a room. Everybody agrees. Sometimes it could be assigned. And again, it's the factual circumstances. You'll get how the parties got to mediation, who the mediator is. Sometimes there's mediation court ordered. The court orders you to do it. The parties may say, this can be resolved. Why don't we do mediation on their own voluntarily? More and more you see it worldwide too, where before you file a suit or right after filing a suit, you have to have mediation. In Italy, you have to mediate first before you can even file for civil cases. So again, more and more countries, and again, our 50 states here, a little different. Everybody has their own jurisdiction, county by county. Some use it, some don't, some embrace it a little more than others, but it is becoming more and more accepted, and because it is productive in moving cases along and get the cases out of court and helping the parties move along in their lives. The mediation process, each part, opening statements. Again, we always look to the general picture and their tournament, a format, if you will, that 60-minute timeline that we have. Again, opening statement, here we have co-mediators. Co-mediators works, first of all, mathematically. So 3 parties on a team move around. It's everybody's having a role in three separate rounds of mediation. They play one of the 3 different parts, the mediator, advocate, or client. Co-mediators work too. They work together, even though they're competing against each other. You want them to work, again, everything is collaborative in nature of mediation. It's collaborative, coming together, not adversarial. So they work together because the mediator is on, if you will. When you have a play, somebody has more active role, the lead role here are the co-mediators. So it's good for them to have co-mediators, because especially in the educational level, instructional tournaments, this is they need a little guidance, if you will. So one party remembers something, they may say, my co-mediator, maybe you want to talk about confidentiality or this or that. So they help each other, if you will, and they strategize before the mediation to how we're going to conduct this, and who's going to share this role, the other role. Again, later on we'll do caucus. Caucus, nobody uses that term in general, but it's a mediation term. Private meetings between the parties to discuss. And that's a key unique element of mediation also, where you have private discussions by this neutral third party, the mediator, where those discussions can only be shared with the other party with the approval of the parties. Nowhere else do you get to have a private conference with a judge. It's a judge, how about we just come back and talk to you? We want to tell our story without the other party. Doesn't happen. And even if you do have pre-trial conferences or settlement conferences, anything said in those conferences are not confidential. In fact, they must be disclosed to the other party. So it's unique here that you have these private conversations, which you as the party and advocate can control what happens to it and what, if anything, is disclosed. The unique thing about that is the mediator, the facilitator, gets a clearer picture. What's here? What's the stumbling block? Who's the elephant in the room? Why isn't this resolved? Is it one of the parties? What is it? The attorneys? Is there bad blood? What's really at the core issue? Knowing that, then the guide, the mediator, can lead the discussion in a productive area. Have you considered this? What about their feelings? Without disclosing particulars and breaching confidentiality, they are a better guide if they know what would really work for them to get a resolution. In a conference, that's when everybody's in the room, the two mediators, the advocate and client on the other side. And again, we'll explain a little bit to the conference. It really had two conferences. The initial one is information exchange and discussion. You can have parties can talk to each other. The mediators can ask the parties, the clients, attorneys can ask questions and discuss things with the other party. Also, unique attribute of mediation also, because you're represented in court with a lawyer and a client. There's no discussion or communication between the other parties. Next one, please, Andrea. Again, there's the format for our tournament. It's a good instructional when you do practice for tournaments and educational in the schools. Two mediators are good too, but not necessary. If you're an instructional, you just do the math. If you have one mediator, two mediator, judge. And again, in our tournaments format, they're judge how well they cooperate. Part of the scoring is how well they cooperate with each other, not against each other. You don't want one to sabotage the other one. Say, wait a minute, I know what's going on. I want you to just be quiet over here. There's, and then you'll see skill level. Some people are more, not just skill level in mediation, but just, again, these are younger students. They're works in progress, as young adults, if you will. Some are more assertive, some are active and passive are the terms I use when I make my judges' comments. Some are more active, some are more passive. Some of that is just lack of experience. Some is just the way people are, their personal style. And I always advocate, again, at this level, they don't know what their particular style is. They're still works in progress as they develop as human beings and students. But it should be authentic. If negotiations the game that everybody plays, especially to win, you have to stay authentic to it. If you overplay it, if the other party, it's a matter of trust here and cooperation. If the other party, if I'm getting played, that you just read some little book somewhere that says, how to buy your car. Actually, that book, Getting to Yes, not a big fan. It's in the 70s, but it's a well-known and accredited. But that's more just to get what you want from the other party. And that's how they define it also, too, is getting what you want from the other party. I disagree. You certainly want to get something of value to you. But here in mediation, cooperative, it's also being able to get it by giving also. Again, you could, if somebody leaves the room and you want their computer and just take it, it's hardly a negotiation. So the theory is it's a little more involved. But again, collaborative effort. So again, not only everybody, the parties, the mediators, how well you cooperate. And it has to be authentic. The parties are actually doing it for the better purpose, as opposed to gaming the other party or trying to beat them in a technicality or tricking them into agreeing. Because really you want the parties to accept the result of the mediation. Then it doesn't have to be happy. Let's everybody all be happy. No, accepting the result. When you go to court, you have no choice to accept or not. The judge says you win, you lose, that's it. You don't like it, appeal it. Mediation, you really want it's voluntary. Again, this is a little broader than our slide here, but it's voluntary. People have to buy into it and accept it. And that's the most productive goal, if you will, the direction you want to go. Mediators, again, in a tournament setting, again, half an hour to an hour, depends on our timing in tournaments. The mediators will meet. They have the general facts. Like these are the up cards if you're playing poker. Everybody can see these cards. One party will get confidential facts. The other party will get their own set of confidential facts, which aren't shared with anybody, just the parties. The mediators don't know what those other cards are down. And the other party doesn't know what the other party's cards are. Their information, their confidential facts, usually their wants and needs. And the cases are generally balanced. So it's not like a one party is going to win this case and the other is going to lose it. And oftentimes it'll say, if here's the goal, the client wants an apology. If you get an apology, we don't care about money. Or the other side might say, yeah, we'd like to, we can't just give money away, but we don't care how much money you settle this for. It has to be settled by Tuesday at 5 o'clock. Otherwise, our company is going to be audited or the sale's not going to go through. There might be other things that they don't want to disclose. And the mediator is there to find these things. So we went a little over the top here. So again, our timeline, 4 minutes and 4 minutes. We have a 60-minute outline we have there. 8 minutes shared. Just again, the suggested timeline, not finite where there's a stopwatch. They should generally meet ahead of time and say, how are we going to allocate the different roles and share the mediator's position as if there was only one mediator. Mediators can just do their own little opening statement and say, okay, now let's forget that. Here's the other mediator. And they're going to do their own opening statement. But generally, a blended opening statement. One party will do the process. One party will do the benefits of mediation. Next slide, please. Let's see where we're at. Again, how you do initially too, again, you start and everybody's in a room. So again, you're actors on the stage, so you're acting as if you are. Okay, thank you, everybody. Please close the door. You need water if anybody has to go to the bathroom. You don't want to elaborate too much on that because you only have 1 hour. Just the general courtesies that you would to share with other parties. People want to know you're trustworthy. Again, part of the mediator's role is, one of the key roles is developing rapport. That's generally, I say, like elevator conversations. Hi, how are you? It was raining today. You see a party has a Cub hat or whatever, one kind of baseball hat or shirt. Oh yeah, my son went to that school. Some commonality is a way also. Some people say, oh, this is a person, trustworthy person. So that's the rapport. Okay, you're not a bad person. I heard you were a no good son of a gun. Wait a minute. So again, so you want to get what they do or don't. Everybody's apprehensive about a legal process, especially the more formal it is. And everybody Googles such and such. They think everything's law and order. They don't really know what's going to go on. So the rapport is, this seems to be a trustworthy person, and I'm going to be fair to people so that, okay, now when we're in a caucus and I'm going to share these secret information I have that I don't want anybody to know about, that I can trust you. And that's, like rapport leads to the trust incrementally, the trust aspect. Why am I going to share all these with you? Why do I think you're going to help facilitate us resolving this today? And you want to be, again, it's your authentic style. If you're just reading, kind of like, again, the younger levels, they will be reading some things, that's okay. But if you're just playing a game, you say 10, I say 5. You say 6, 7, I say 8, whatever the case, just reactionary responses, tactics and counter tactics, I call them. Or is it thoughtful? Is it really with explanations, not just yes, no? Here's why I want this. Here's why I can only accept. Our insurance adjuster can only authorize me to pay $35,000. They only have a $1 million policy, insurance policy. That's all they have. If anything, you go to court, get a $10 million judgment, you're still only getting $1 million tops. So they explain things. So opening statements, rapport and trust, explain the parties' roles. Here I am today. We as co-mediators. Again, general introductions. Hi, I'm Bob Smith. This is my co-mediator, Mary's Jones over here. We're going to be here working together to help you to resolve your differences today. Hopefully you can get, if everybody commits to this, it's going to be everybody's going to be respected. The parties' roles are going to explain to the process. Parties' roles, I'll read these bullet points here first. The parties' roles, here's what I do. Here's where we're going to be. And I'll get into this a little more as do a sample mediation. But here's what I'm going to ask of you, this party here, that party there. Would you introduce yourself first? I'm the head of this company. I'm the advocate for so-and-so. General introduction. Okay, thank you. Fine. Confidential. Then you get into that, generally what the parties general introductions, that's rapport and trust. And then the mediator defines the roles, not just the roles, but the process of mediation and what's going to happen that day. And you really want the parties to commit to the dispute resolution process, to work collaboratively explaining the benefits of mediation, what it is and what it's not. It's not trial. I'm not a judge. I'm neutral. I'm here to aid you and guide you, but it's ultimately you control what your destiny today. And that's one of the key benefits of mediation. The parties control what the resolution is, all the different things you can get in mediation that you can't otherwise get in court. Court, you're defined on what you can get. Here's you get money or whatever, you win, you lose, that's it. There's no apologies or nothing else that's on there. In mediation, parties can agree. It's a matter of contract, ultimately the resolution. You can agree to whatever the parties voluntarily agree to. And what you control, that not only what happens, but you control what is or isn't disclosed. Next one, please. Okay, so we have a couple that's the you know what, let's do this a second here. Let's all right, we'll do this here. The generally here, so you have one or two mediators here. We in our format, we're going to have two. Here's a sample which you can read in a bit, but these I'm going to give you some of the bullet points initially here too. So here we have 8 minutes to do. So if we have co-mediators, you'd introduce yourself. Sir, first of all, hi, I'm John Legg. I'm the mediators. You know, you've all chosen and agreed to mediation today. So thank you, thank you, thank you. Find 100 different ways to show gratitude. If you say thank you too much, it becomes repetitive and puts people asleep. Thank you. I appreciate you all being here today. I've read all the information we've had before. That would be the general facts. I have a general understanding what's going on here. I want to let you know that I'm here today. And again, if it's a co-mediator, my co-mediator, so-and-so, we're going to work together to help you today. But if it's just one mediator, we'll do the statement. And you're developing rapport and trust. So rapport, thank you, gratitude for the parties. Thank you. Is everybody okay? There's water if you had to go to the bathroom. Again, we've all agreed to spend, you could say, not because of the rules of the tournament, we've all agreed for a 1 hour period to use our best efforts to either get this case resolved or get on the way for you, on the way toward that path towards resolution and another date. And you could leave these, the end of, you have 1 hour, if it's not resolved in total, it's like, okay, well, here's what we do. I think we have to finally, we've come a long way here, but why don't we all agree to meet in a week or two and we'll come back and be productive. We can think over this and come back. So it's not like I'll see you in court, get lost. Generally, these are conciliatory and cooperative, if you will, the parties. So it doesn't have to be all, it can be settled and resolved, especially if the confidential facts say, if you can get this, take it. And if you can get that, take it. And if those two things mesh, both parties should settle the case, and ideally, but it's not necessary. All right, so you cover, again, rapport, general concern about the parties, and trust, introduction, who I am. And again, if there's any, sometimes people can go, anybody, what's your preferred nouns, whatever the case you may be, pronunciations and names. Parties generally go with the role they're assigned, if you will, as something of a staged event, if you will, because you're playing the role of the doctor or whatever the case may be, or you use your own names. Generally, they're gender neutral, so you can be Mary or John or whatever you want to do, Johnny, Joni, sort of, you know, or use your own name, whatever the case may be. So the parties don't have to worry about that too much. So gender neutral, so the parties can be male, female, whatever they want. So when the rapport and trust is when you tell the parties what you're going to do, and then you do what you say you're going to do. That's how, not, you know, the snake oil salesman, hey, trust me, this is a good deal. No. Everybody can say, trust me, but why am I going to trust you? Why? I've never met you before. How am I going to trust you? Why should I trust you? To be a fool to trust them. So you tell them what you're going to do, and little by little, incrementally during the process of mediation, you do it. You tell them, here's where I'm going to be fair. So are you fair? Do people perceive you to be fair? I'm going to be balanced. Are you spending 10 minutes here with the one party and only 1 minute with the other? It's like a pool table going one way or the other. The perception of fairness has to be in fact true. That's how you earn the trust of the parties. You say what you're going to do and the types of things you're going to say. One would be the mediator role. Now, if you have two mediators, they can say, I'm going to do the mediator's role. You do the process. I'm going to do the benefits of mediation. So what some things you would say, I'm a guide here. I'm a facilitator. I'm here to use my best efforts. And again, at that point, they know that you've been around. You have some criteria, professional criteria. I've been a mediator, short and sweet. I've been a mediator assigned by the courts. I have a great deal of experience in it. And I think working together, perhaps I can help you and guide you a little bit further than you are today. And perhaps we can all commit to resolving this by the end of this. But here's what I want. You want the parties. I will commit to using my best efforts to guide you in resolution, but I want the parties, Marion Smith and Joe over here, I want you all to commit that we're going to use the time we have today to work cooperatively, and appropriate and professionally and courteously to work towards a resolution. If everybody look at all the skill level of this attorney, the skill level of that attorney, and the parties here, you've all committed to mediation. I know you want to get this resolved, don't you? Yes. Did you get them to say yes? It's the commitment to it. Go in the right direction, not pointing fingers. Distinction from trial, where it's always, I want this and I don't want you to get it. So they have a common interest in getting it resolved. Get them to commit to that. So here, I'm the guide. I'm a facilitator. I will be neutral. What I do for one party, I do for the other. I am not a judge. I try to gain understanding and use my efforts to guide you toward what I'll consider to be a resolution. I'm not going to tell you what to do. I don't judge what you're going to do. I don't evaluate your positions. We can discuss things, but generally here, I'm going to be fair, balanced for both parties. What I do for one of you, I will do for the other, and I will be neutral. I'm not going to judge one or the other. I work for both of you, not against either one of you. What I do is, again, as a mediator, what I will do, I will generally control the process, and the process, which I'm going to get into in a couple of minutes here, I'll explain to you, but generally it's fluid. I will go with what the parties agree to do because you can control the mediation, but I want you to commit to, let's all agree that this is the established process we're going to go along with the caucus and conference, which I'm going to explain to you. And again, if we all do that, I think it will be the most productive hour that we can have. Everything you tell me, you can talk about confidentiality. Here's some of the benefits. I'm going to control the process. Everything happens here in mediation today is confidential. And you can also explain what do we do in the caucus is confidential. Nothing gets published after this. Nobody knows that you even met or had a dispute. You can control the message you give, if any, to the world after this. You can have your reputations restored or protected if you wish. Those are part of the possibilities of your resolution here today. The benefits of mediation, first of all, the cost and time. You've been in trial here for 2 years already. You spent a lot of money as lawyers, and then you also could say, well, it's money well spent, I'm sure, because these are very good lawyers. However, the time, you have no idea. The thing is, you don't lack in court. You can all go to court and you always have strong positions. I understand it, but you all realize the value. You can control what happens. You can get results. You can get remedies that you can't get in court, and the uncertainty. Both of you could win, both of you could lose. Probably you get something, both of your parties aren't happy with your resolution in court, but you do know you're going to spend a lot of time, money, and effort in the court, and it's the uncertainty. So there's a benefit in of itself of the certainty of your outcome here today. You as the parties control what happens, the process, not limited to the other remedies, and then explain the process. We're going to have opening statements, caucuses, it's private conversations, and then we're going to have a conference. And I ask you, again, when we hear, not interrupt everybody. We're going to treat everybody with courtesy, decency, and respect. Can I get well to agree to do that? And you want to get them to commit to do that, because later when they start screaming and yelling, you go, remember, we're all going to agree to do such and such. Remember, we all agreed to work together collaboratively. I ask you for patience also. This could be heated. Sometimes it's emotional. I understand. But I think there's, at a point, the parties need to discuss these things. If it gets a little too hot, if you will, then we could, if you will, I'll suggest that we go to caucus so we can be a little more productive. And then the process, what you're going to do, and the agenda, the benefits of our conference, we're going to establish an agenda. You've been negotiating, trying to resolve this. We're going to work together, if you will. I'm going to ask all of you to work together to pick like 3 to 5 of the main issues here. What are we really going to discuss here today so that we can best use our time together? Okay, any questions? If not, everybody agreed to this, get them to do so. Thank you. So now we'll ask, generally do the plaintiff here, you're the party here. We'll ask your brief opening statement now at this point, and that's okay. And then we'll also ask, again, you tell them we're going to be fair and balanced. Then after you've given perhaps about a 5-minute or 10-minute opening statement, I will ask the defendant here, it gives same opportunity to give your opening statements. We'll ask you to, I want you basically to give us a short synopsis of the facts and where we are, the status in the case, and what it is you're looking for here today. So we know the other party knows what you're looking for. And then we'll ask the defendant here to do the same. Next. Good. Andrea, thank you. So that generally the bullet points the mediators can put in there. So then you move on to the advocate. Here it is. So generally, in a structure here, I like to do, when I teach and put these out there, I like to have the general accepted model. So the advocate would be the first one to speak as opposed to advocate and the client. And I call them trophy hunters. When you do tournaments in law schools that people have been around, in different countries are different. In India, the advocate, or in the ICC in Paris, the commercial mediations is not American ones. That's more client driven, and the advocate sort of takes a back seat. To me, it's more in that model. I don't prefer it. It's more expediency. Get this dispute done and move it on. And the parties who facilitate it, the International Commerce Commission, that's a business revenue businesses support them and pay for their organization, and they want the cases just to move them along instead of going to court for years and years and have a forum, an international forum. So it's less mediation and more expediency. And traditionally, I like to hear, and when we do our tournament level, the advocate. In the real world, generally, you pay the advocate. In the American system of jurisprudence, advocate says, "Hi, I'm so-and-so. I'm representing Mary Smith is here. She'd like to say a few words in a minute, but I just want to discuss with you where we're at on this case. You've seen that we all have this general facts, but it's important for me to point out 2 or 3 things. We never got an apology. We've asked them 20 times, why this, why that? We've never got a response. We can't really resolve this until we know A, B, and C. So that's one thing we want. That's an impediment for us to get this done. So you get some of the bullet points and commitment. So thank you, Mr. Mediator. Appreciate this. Counsel, I appreciate, again, conciliatory language and acts. Thank you. I appreciate being here. We had sent some nasty letters back and forth and all kinds of pleadings. However, we realize that's part of the law and business, if you will. But I think today we have enough information that all of our best efforts, we work together for our mutual benefit. I think we should be able to resolve this case, if not entirely appropriately, some sort of commitment to the process. I'm looking forward to working with you and collaborative and cooperatively, not giving up and being overly nice. Don't equate niceness with weakness. Sometimes it'd be very firm. Yes, we're here to resolve this case. If we find a reasonable response from you today or a reasonable offer, we certainly would. It's a little aggressive, but it's a personal style. Again, so here's the areas agreement. There was an auto accident. Here's what happened that one day. There was an accident. The issue is we said it was their fault. They said it was our fault. Obviously, the only way to find that out ultimately, if we don't agree, is go to court. And neither one of us neither one of us know how a judge or jury would rule on that, perhaps. So that's one of the reasons we want to resolve this. So even if we were to pay some money, how much money we're going to pay, we want to do is come here. We are certainly willing to pay what's reasonable and fair under the circumstances. Everybody can couch it in terms of generally fairness and reasonableness. But again, what it's not is don't say you were at fault, you broke the law. All these things happen because you're bad. Those accusatory statements are not conductive. This is collaborative, going in the right direction together toward resolution. And then here's what's agreed to. Here's what's not agreed to. Next slide, please. Okay, you read these two sort of, and I kind of just gave a little bit of that and keep our time good here too. Kind of what you would do. Here's the short, sweet. Then the mediator would say, okay, thank you. Here's what we're at. Now I'd like to, my client, Mary Smith here, she's the head of the company here. She was driving the car. She's the owner of the business. Would like to address the mediator. And then again, generally it gets that pre-game jitters out. People want to say a few words, but they're at comfort level because you, the advocate, are gaining the trust and guiding the client. If they just come out there and start talking on their own, in the real world, they're nervous. They don't know what to say. They want to be accusatory. So you lead them. You set the table for the client. So then the client says, "Well, thank you, John, for thank you." You'll see too in this level too. They pat each other on the back a little too much in some respects, but that's the nature. They'll say, "Oh, thank you, co-mediator. That was a great opening statement. Oh, thank you, advocate. You're a great advocate." So they kind of, it's effusive and bubbly, if you will, but you'll find that I don't judge against it, but that's how they learn 1, 2, 3 when they get experience after the first round. As a judge, say, okay, maybe you want to just say, we'll be the judge, not you, how well they did there. So you rein it in a little, but you'll see that it's just human nature. So again, thank you, advocates on. So I appreciate what you're doing here. So yes, I am here, as my counsel told you here today, with the I clearly want to resolve this matter. We've been in court for 2 years, And as you know, as much as I like my attorney John here, I'm paying him a fortune. I can't keep paying him so much. I'd like to get this resolved in an expedient manner. And if today we can do that, that would be the best thing in the world. It's not, and that's here's where you can put the personal. Most of these cases have an element of personal angst, bad blood, personal, emotional attachment, if you will. And that could be the stumbling block as a mediator, is that they just don't like each other. They feel they were disrespected. They don't get the respect. They fired me after 30 years. You never told me why. So here's what you can, there's where you humanize it. You know, I was working all these years. I did this. I was driving my car, doing nothing. It was a brand new car at 40 miles on it. I was sitting at the red light, and this kid over here plows into me and smashes the car. My insurance won't even cover the whole amount, 10,000. As soon as I drove it off, that lot's worth 10,000 less. You know, the realities. And it's like, you know what? I was sitting there, my arm hurt, everything else. And this kid, you're trying to keep the terms. This person here never even said, how are you? Anything else. I says, what? They didn't even say hello. They didn't call the police, didn't do anything. He hit me and didn't even say, hi, are you okay? Can I call an ambulance or anything else? So a lot of times there's that personal animosity. Is it why it is? Well, you know, good son of a gun, you didn't show me any concern at all. And so the other party here could say, you know, I didn't realize that. I was, you know, the first accident I ever been into. I realize now that you were hurt here, and I'm really sorry about this. So you can humanize it, if you will. Those are conciliatory words, if you will. Not like, yeah, I didn't go to see you because you were at fault, not me anyway. That it's not conciliatory. So, but put it out there. If there is some personal, again, limited, not accusatory, you broke the law, you know good, this, that, you know. And again, if parties do that, the advocate first could be to rein them in. Okay, Mary, I think it'd be more productive if we stick to the facts here, and we can discuss it a little later in the caucus. Rein them in if they get a little too heated. Tea kettle has to boil a little bit. People want to have their day in court. If they're not in court, they want to have somebody. That's where the third party neutral, the mediator, they want to have somebody other than their lawyer and their circle of friends, their story. They want to tell their story, why I was right, it's not fair, here's what I feel. They want to have some sort of day in court. They want to have their stories heard. And there's huge value to that, as opposed to court. In court, nobody gets to tell their story. You say yes, no. No, can I say something? No. Your attorney asks questions. They don't get their story out. It's extremely frustrating. It leaves a lot of animosity after it, even if you win nominally in court. So again, here it is. Then the party says, here's the personal thing. What we really want here, we want a good business relationship. We've been working together, selling widgets, you and buy and sell. We have no idea why there's something wrong here, but I think we need to resolve this. And we have these new contracts. We can even make more money and continue on and on. So the business or personal relationship could be key in these. Sometimes it's a one-off, just an auto accident, something like that. There's not as much personal. There could be personal animosity on the nature of the case and the disinterest, but it's no relationship in the future that they're really concerned about. And the advocate, again, to the client, you go to the next one. I'm really going on the client's opening statement here. Thank you. The factual information. Again, if it's highly technical company, the lawyer shouldn't be saying, well, the widgets are made this way, that way, and how it's done and how many employees. The owner of the company is the one that knows this information based on the facts of the case. Personal stories, again, stay in their lane, so to speak. Sometimes you'll find one of the parties here in an educational setting that one might be the better advocate or mediator, and they'll overstep the role and they start saying, well, this case here, and legally speaking, and confidentiality should include A, B, and C, and non-disclosure agreement, talking like a lawyer, if you will, as opposed to the party. So it is a bit of acting, if you will, to stay in your lane, if you will. Next one, please. Okay, that's pretty much it. You can read this here, if you will, just tailor-made to the settings. Opening statements, generally, you find they can be sort of canned. Opening statements too, when you're judging, sometimes you'll find, wow, that's a really good opening statement. They're really good, or mediator or parties. A lot of it is prepared and rehearsed, and you'll see a lot of them will literally read it. It's like what you see on the screen here today. First, I want to thank media. They'll kind of read it, which is okay. It's learning, and the level, the skill level, that's fine. It's nice. And after the first round too, I say, okay, you got your first round in now. So eventually stay with the color within the lines. Next round, that once that comfort level is there, try and put the paper down, come from the heart, be authentic as opposed to just reading. And it's without judging them too critically, because this is new to the parties also, to these students, if you will, especially middle school. So a little bit, let them go through the motions. At least they covered the boilerplate. And the opening statement can be one size fits all. You just change the names to the circumstances. Generally, you're still doing the same thing with everybody. When you do the conference and the caucus, that's where the artfulness, the skill level is there, because it's not scripted. There's the bargaining. Here's the question and answers. Here's the clarification. The mediators coming in, which will handle that next week when we do conferences, if you will, or next session. So again, that's the nuts and bolts, if you will. And the time level, advocate client, one team should do, again, 4 minutes, not set in stone, perhaps 8 minutes between the two of them. So the co-mediators, 8 minutes total, advocate client, about 8 minutes total for each side. Because then when you look at the timeline too, how many minutes here and there to do negotiations, how many the initial conference, the caucuses, back and forth. Opening statements, again, prepared in advance. This is the type of thing with students you can prepare them. Here's sort of a general open statement. Instead of doing a whole mediation, today we're going to do, I call it like 5-minute speed dating, 5 minutes. Okay, you have 5 minutes here. Here's a case. Any case, you're this party, that party, give us an opening statement. And generally, you want to have your bullet points: confidentiality, neutrality, control, conference, what the process is, what the role of the mediator, if you're doing the mediators, if you're doing advocate client, what are the basic things you're doing? Hi, I'm so-and-so, introductions, commitment to the process. And that's universal. Everybody should commit. It's better if they do, not necessary. Committing to the process. That's like that. Yes, we are working here together. And then they could be reminded later when they start not working together a little bit. But then it's a skill, tool that the mediator has. Remember, we did all say we're all going to be fair and nice. Remember, we all said, no matter what, we're going to use this hour, even if it seems like we're going in the wrong direction. We're going to have our patience, and we're going to try again. We're going to use our best efforts to get furthest, as far down that road toward resolution as we can. Or today, correct? We all did it. Can we? So pull them back in, if you will. Cooperation, or mediators, it's a skill level, but near opening statement, encouraging cooperation, solutions rather than assigning blame, understanding, not judgment. I say judgment has no value at all. It can be satisfying, but it has no value. Understanding has value. Why do you want this? Why do you want that? What do you really want? And those are confidential facts, how to mine those. And there has to be that level of trust and rapport between the mediators and the parties with each other. I'm not going to disclose this until I know that we're going in. You're not just going to use it against me somewhere down the road in court. Flexible, adaptable, just to the mediation progresses. You never know where it's going to go. It could be, it's a bumpy road, and that's why the mediators are the guides. I actually have it over here. It's a yak herding stick, actually, when I was teaching in Kathmandu. So when you're on the Mount Everest Base Camp trail over there, you have yaks, yak trains and yaks, and there's no roads. And on the edge of the path, or dirt path, is the abyss. You fall off there, they never find you again. So they are the yak herders. You the stick. I had one made, actually. They gave me, is that basically it's the guide. That's the mediator. You're leading from the rear. They're kind of like making sure they go in the right direction. If they start going toward the cliff, they have to rein them in back to the other way. You kind of lead from the back. You can beat them over the head. You're probably going to get knocked off the cliff yourself. Guiding them. Sometimes they tap them a little harder, or sometimes they actually throw a stone or two at them to keep them going in the right directions. And in the end, you have to stand on the right side so you don't get pushed off this cliff too. So that guide, you're guiding them. Sometimes you push in a little more. Sometimes you tap them on the head with the stick a little bit, the herder stick, but you keep them going in the right direction. Because if it's a free for all, death and uncertainties all around you. So keep them going in the right direction and aiding the parties.